first case to come before us this morning is Joshua McCormick versus Lydia McCormick. Both sides will have 15 minutes to present oral argument. The appellant may reserve up to 15 minutes for rebuttal. If the appellant wishes to reserve any time for rebuttal, please let me know when you get started. I'm keeping the clock, which you'll also be able to see over there on the wall. Please don't use the names of any minors or victims. I don't know if that's going to be relevant to your argument this morning, but we are recording this. It will be posted on the course YouTube channel, so we always give that advisement. We've read the briefs. We're ready to see when you are, Counsel.
Thank you, Your Honor. I'd like to reserve 2 minutes. May it please the court, I'm Attorney Alexander Folk on behalf of the appellant. In spite of my brief apparently saying appellee, I'll point out my own errors. The issues before the court are largely factual and interpretation of past orders, as well as an interpretation of the law. In the first issue I'd like to talk about is the issue of the stimulus money, and the issue that during the trials phase of this, there was literally no argument that this was stimulus money. There was not a significant amount of discussion whether it was tax credits or how it was phrased, but it was money that was out of the ordinary. It was not typical. When you hand thousands and thousands of dollars to the parties, I don't think Congress is going to go nitpicking, well, in this instance we're going to do this, in this instance. They're just trying to get it through and get it out to the people. Unfortunately, we have a situation where these folks, there was no anticipation in most decrees back then, and I was doing them back then as well, for an anticipation that there would be extra money. You know, I understood tax credits in terms of, you know, tax dependency exemptions, those kind of things, which is what the original decree talked about. The problem was that tax dependency exemptions were actually done away with in 2017, well before the stimulus came out. And they're still not in place. They're deleted until 2025. So technically, that decree only says tax dependency exemptions, claim to children, etc. But for purposes of tax dependency exemptions, it was limited to that, and that was eliminated. So you have this free money essentially coming out, and the question is what, in our view, and what the appellant's view is that that money should have been allocated in an equitable fashion. We don't believe that that was done. It was just simply said, well, it went to him, so therefore he can keep it. He doesn't have to share it. He doesn't have to apply it to the benefit of the children. And that he got it in the name of the children, in the sense that that's who it went to. It was allocated to those children. There's really not much of a question about that. When the objection decision came out, it simply said, well, we're going to talk about all all this statutory stuff that the parties never briefed, never argued, never had an opportunity to. We said, look, this money should go to the benefit of the children, and it's more fair to send it to her. It's more equitable to send it to her. She has the children and had them throughout that period of time. And the court's position was, well, simply put, he got it, so therefore he can keep it. There was no analysis. We believe that that was an error. The second question, fundamental, is the issue of the transportation. The interpretation of plain language in a decree is not really subjective, it's objective. It says the transportation cost. There wasn't a question whether it was the transportation cost, and the is encompassing. And we use the word all in a substitute for the, and we didn't use his or hers. And what was interesting about this analysis was that they said, well, not her expenses for transportation. So her expenses for transportation shouldn't be considered because that, you know, he wasn't ordered to pay her transportation expenses. But the problem was the transportation was his responsibility, all of it. All of it was his responsibility. And it was a court order. And neither party appealed. Neither party went and said, hey, we don't understand this. Everybody understood it. And both parties agreed that he stopped providing that transportation immediately after the order came out, in terms of flying in, picking the children up, and then flying them back. And that was contemplated at the time of the original decree, that he was going to be doing that. Now, at some point in time, I could understand where the children are going to be old enough and be able to do that, but there's still an issue of getting them to and from the airport. Ordinarily, I would say, probably not that big of a deal, but when you're ordered to pay the transportation cost, and then you don't, and she asked him, the testimony is clear in the transcript that she asked him to give her some money for that transportation, he refused. He was ordered to do it, he didn't do it. We didn't file for contempt. I don't think that's necessary. I don't think you're required to file for contempt in order to enforce an order. You just simply say, hey, pay me. Pay me what you owe me. So I think that ultimately we have the issue of whether or not, there really wasn't a question whether the distance was correct or the cost was correct or the amount that should have been paid per hour. None of that was really an issue. The question was whether or not he had to pay her for doing the transportation. If he had hired somebody privately, he would have had to pay them to go do that.
Counsel, on the issue of paying wife/mother, I note that one of the aspects of what was sought was actual payment for her hourly time.
Yes.
Was there any information, any evidence that she had to take off of work in some way in order to transport those children to the hospital? God forbid, I'm sorry, to the airport.
She did testify that while she was not employed full-time, there were other things that she was doing in order to get paid that rate. At the very least, it could have been, the argument could have been minimal, at least it could have been a minimum wage. But she was saying she was being paid to do other work at that same time. I believe it's in the transcript in her, I can't cite the exact location, but I'm pretty sure that that's exactly what she testified to. There was the issue of, again, I think I've stated that the issue of, there was a spousal support offset. I talked about spousal support offset in a handwritten notation on the order regarding the cost of parenting time being $7,000 a year. In the issues, when you talk about the issue of expenses and equity and fairness, which I think is part of the best interest, and the domestic relations court is a court of equity. It can allocate in an equitable fashion these expenses, and the court did that in the original decree. It said you're going to have this excessive expense, and when you look at the factual basis of this trial, he's not spending $7,000 a year because he's not traveling to go and get the kids. So he's not only not spending the money, but he's shifting the cost. He's shifting the cost from himself to mother. And if you look at the data that we provided during the trial, mother has never made more than about $7,000 a year. She does have 2 other small children, which she never made as an excuse. She said, you know, this whole time I was home with the children, etc. But she made the effort to make sure that the children were delivered to him, and we think that she should be compensated for that time. Thank you. I'm going to leave it for that. If there's no other questions.
Thank you, counsel. You'll have a full 5 minutes for rebuttal.
Good morning, Your Honors. My name is John Green. I'm the attorney for the appellee, Josh McCormick, in this case. I'm going to confess right off the bat. I I wear hearing aids, although I've heard everything that has been said and asked. Just apologize in advance if I'm asked a question and I ask for it to be repeated. So thank you for your consideration. May it please the court, this case, there's two central issues in this case, and they're not extremely complicated. The first one issue, it deals with what is inappropriately called stimulus funds. This is, there was a federal statute that was enacted during the coronavirus. It was referred to as the CARES Act. And what it actually is it's a tax rebate to the taxpayer who is claiming children on their, in this particular case, claiming the children on their income taxes.
Counsel, I have a question for you, and I'll try to keep my voice up.
Thank you.
You said inappropriately called stimulus funds. What were they called during the hearing before the magistrate?
They were called stimulus funds.
And when did this concept or explanation that you were about to give us first come into play here?
I think it was just the vernacular that was used during the time. The common vernacular amongst people was what they called stimulus funds. It was just portrayed, I think, in the media in different common circles. But when you read the text of the CARES Act, it was a tax rebate to taxpayers. And in this particular case, when you look at it, the transcript is pretty clear. When we talk about the providing financial support for the children, the father was providing financial support. So in essence, father has worked a full-time job. He's paid child support. He pays the taxes on his income. Conversely, mother, the testimony is pretty clear. It was clear at the time of the trial when the initial divorce decree was enacted, had a very infrequent, spotty employment record. In fact, in the brief, it was intimated that essentially mom was adversely affected by the pandemic and had this loss of income. The transcripts actually demonstrate mom made more money during this period than she did the year preceding the pandemic. So, but roughly her income was somewhere around $2,400 to $3,000 per year. This was the same information or similar information when you look at the decree when the court decided to allocate the tax dependency exemptions, and the court allocated those to father. And when you look at what Congress did, Congress had a variety of things that they could have done when they passed this legislation. They could have said the funds will go to the party and under certain conditions or circumstances. They didn't. They said the funds were allocated to the person who had the tax dependency exemption. In this particular case, that was father. There was, I know there was a discussion about best interest of the child, and I think Higher Vice Code 310904 was cited in the brief, and that doesn't deal with the financial aspects of support, deviations. It deals, the best interest of the standard deals with the allocation of parental rights and responsibilities, custodial designations, not the financial designations as it relates to this. And one of the other important things I think that, what's being asked is essentially Congress enacted legislation that they decided who's to receive these funds. I think the Supremacy Clause dictates that you follow what Congress has enacted in the allocation of the tax credits. And in this particular case, that's what's happened. And what the appellant is saying is that essentially now every single court, he's asking for a holding that would require review in every single case. So in other words, what parent received it, whether that parent should have received it, how that money should have been allocated, it would just absolutely flood the courts. And that's not what Congress did. In essence, when you look at other versions of this, for instance, there was additional funds allocated for those that were unemployed. Well, Congress didn't allocate those funds based on the amount of money you were making. They allocated $600, I believe, weekly no matter what. And so it was basically universally applied. And I think in this case, that's what it did. Additionally, there was discussions about travel costs, and I'll kind of get into that. But when the court looked at that and made that designation, they took these things into account already. I'd like to turn to the issue of the travel costs. So, as the record illustrates, these individuals have been divorced for several years prior to the filing of these post-decree motions. Up until just contemporaneous with the filing of the post-decree motion, the mother had never requested of father a reimbursement for any travel costs to transport the children. In essence, when you go back and start looking at what was going on at the time these folks were divorced, the children were much younger. So initially, when father was, when they were during the process of divorce, father would travel back to the airport where he would be met and then fly back with the children. That was just basically because of their ages. Eventually, additional money was paid by him to have somebody accompany the minor throughout the trip. They're currently at the age where that's not necessary. So when you look at this, mother essentially, just prior to the filing of these motions, and the transcript is clear, and she admitted this during trial, was she simply hands him 4 years worth of invoices, and as part of that, she essentially says, you owe me all this additional money. And what's interesting about this is a couple things. When the court issued the decree in this case, and when you look, and Horton is very clear that if there's some ambiguous terms, the court has the ability to define what it meant, which the court did in this case. And of note, when there was testimony and the decree was issued, if the court intended that mom should be paid a salary or a wage, or mom should receive mileage, the court could have very clearly stated that in the decree, and they could have set forth how that will go. They could say that mom will be reimbursed at presumably a government rate, or mom will receive a certain amount of money in order to transport the children. And in this particular case, mom just set her own wage. Mom just said, my time, I think, Your Honor, you asked the question about how she determined or came up with that wage, whether she missed work. The transcript was clear, she did not miss work. She was not working. And she simply said, I called around a few places and I figured I was told a secretary should make approximately $15 an hour, so that's how I determined the wage. Well, you can't apply the standard. You can't essentially say that mom can unilaterally decide how much she's going to charge to drive children to the airport. And I will say, and I think the reason the court interpreted the decree the way it did is, in the hundreds of thousands of cases that go through the Summit County Domestic Relations Court, I've never seen a case in which the person who would drop the child off at an airport or somewhere actually receives pay for doing so. So I think that would set an entirely dangerous precedent to essentially go back and say every single person who has long-distance parenting time in which a child would have to get on an airplane and travel, that the parent who is taking them to the airport should somehow be reimbursed a wage for that. So I think that would be entirely inappropriate. And I think that is all I have at this point, unless there are any questions.
Thank you, counsel.
Thank you.
Very briefly, there was never any testimony that Mr. McCormick paid any money to provide transportation. There was no testimony at all about that. think it matters when you ask for something that's been court ordered. Certainly, once the children reach 18 and they're gone, and you say, oh, by the way, now pay me. But in this particular instance, sometimes people don't go back to court for little things, they go back for all the things. So when you have to follow the court's rule, this particular court in Summit County requires you to follow a form that you have to fill out the form, you have to provide all your documentation, you present it to the other side, and you give them a reasonable time within which to pay. That was followed. So to say, well, essentially to make a latches argument, when you have a court order, it would be very difficult to do that when you're dealing with support and those types of things. Addressing the issue of secretarial wages, she testified that she actually was performing secretarial services, and that's the wage that she charged. I don't believe it's a dangerous precedent when the language of the order states that one party, one parent, shall pay the cost of transportation. The interpretation is what transportation means. And I don't think it's very hard to extrapolate out that transportation includes travel in a car, travel through the airport. Those are transportation costs. I don't think the Supremacy Clause applies when you're dealing with money that's allocated to children, in this case, children that were subject to a court order. So I believe that this domestic relations court had the ability and the authority to allocate it in a way that is beneficial to the children. The tax dependency exemptions were allocated to father. I was at that trial. And the dependency exemptions were allocated to father because his father was the only one working and the only one who could benefit from them. They have never been changed because he always would benefit from them. And his income only went up throughout the years. The original allocation was about $70,000 a year. By the time we went back to court, he was making over $100,000 a year, almost $110,000 a year. So when you talk about the dependency exemptions, he clearly would be the one to benefit from them. But when you talk about this rebate, call it whatever you want, stimulus, rebate, whatever you want, it's essentially a windfall. It's essentially offsetting against all of the things he was ordered to pay. He was ordered to pay the cost of transportation, he was ordered to pay child support, and when you give him $5,000, it pretty much offsets all of those expenses and then some. Not all his child support, but all the transportation expenses and then some of the child support as well. So you kind of taken out his skin in the game. That's all. Thank you. Do you have any questions?
Thank you both for your presentations today. The court is going to take the matter under advisement. We will issue a written decision, which we will mail to all parties. Thank you.
Thank you very much.
Sorry.